Well, good morning, everyone. You are very welcome to our second day of activities within the framework of our first international workshop on the philosophy on the private law. And we are very, very happy to have with us here Professor Francesca Benatti. She's going to to make a presentation entitled The New Functions of Tort Law Between Political Legitimacy and Social Justice. So without further ado, the floor is yours, Professor.
Good morning. Thank you very much. I want to thank Professor Papagiannis and the University of Girona for having me, and I want to thank also the international, the Red of International Philosophy of Private Law. My presentation is based on an ongoing research about the changes of tort law in civil law system. My perspective is from a civil lawyer. So the debate on functions appears complex nowadays, given that in recent years almost all legal systems have adhered to, expressly or implicitly, I would say, to the thesis of multifunctionality. This is shown by the recognition of the punitive function in civil law systems that once was typical just of common law systems. If the abandonment or reorganization, especially in theory, of the compensatory function is clear, a systematic and organic reconstruction of the current panorama appears difficult. First of all, any analysis cannot ignore a historical assessment. Scholars have pointed out that the function of civil liability are not static, but that each era sees a prevalence of one or the other, depending on the values and objectives of the system. Moreover, they also depend on the social, economic, and political context in which the rule operates. For example, in a system in which the welfare state is efficient and effective, the compensatory function is less important, is less fundamental. The objective of compensation can be achieved through no-fault schemes, as happened in northern countries or in New Zealand. The opposite is the case where the absence of social protection makes recourse to civil liability fundamental. And in this case, we see the way in which welfare state and civil liability are close. Alternative deterrence can be privileged only in certain sectors in which the aim of discouraging certain behaviors appears more relevant or to facilitate access to justice. It is clear that this determines an impossibility to evaluate function or, in any case, to hierarchize them. A further profile that affects the examination of the function concerns the method used. The formalist legalist method focuses more on compensation. Adherence to economic analysis of law leads to a valorization as objectives of deterrence and reduction of social cost, even distancing oneself from the normative datum. A constitutional reading of civil responsibility conceives it in a different perspectives, in a perspective of sustainable solidarity, attentive to the balancing of the values and principles involved. In this case, the real problem is how we balance them. What is the parameters to balance them? However, it seems appropriate to note that no method is always adequate or meets all needs. One or the other might be preferable depending on the purpose. A legal system may wish to sacrifice efficiency in some cases in order to achieve other goals, or they may be balanced. At the same time, even if we stick to the idea that tort law needs to achieve justice, there are many definitions of justice. Social justice, the same concept of social justice has different meanings. So finally, the ideological perspectives that justify the different functions must also be considered. Redistribution can only be framed within a certain vision of the political, social, and economic system that is to be built. Moreover, the criticality of this purpose must be noted. Many Italian legal scholars note that compensation does not always serve to achieve greater social justice. This difficulty in framing and categorizing derives from the very nature of civil liability. More than other areas of law, it seems to escape precise and general categorization and lives in operational reality. It is no coincidence that its expansion has been the work of jurisprudence with the support of doctrine, often faced with specific problems. It is clear that it is an elastic and flexible institution used many times as an instrument of social engineering or for important political battles. In this perspective, the Dutch decision on climate change are emblematic and appear understandable only with regard to the policy objectives pursued. On the other hand, already at the beginning of last century, facing the extension, it was the beginning of the extension of this rule of torts, Riepert noted that this explosion was not dictated only by a moral thought of justice or charity, but that a deep democratic sentiment imposed reparation as a redemption of activity and protection of weakness. He said that it does not mean to make an indictment of all norms inspired by the democratic spirit. He was simply pointing out the spirit that dictates these reforms. So, tort law reflects the changes in society, and at the same time, tort law shapes society. So we see in how the changes in society many times change our rules. From a practical point of view, it is also not easy to distinguish clearly between the different functions, which on the contrary tend to intersect. The doctrine warns how non-economic and punitive damages can be at the same time compensatory, deterrent, and punitive. When does compensation become a sanction? The compensatory function itself very often turns out to be a fiction. Faced with certain losses that cannot be quantified, compensation becomes an illusion. This is why many scholars say that it is better to focus on apology, to focus on nominal damages, because what is needed to be recognized is the offense to the dignity, not the economic compensation or a sort of economic compensation. It has been rightly observed that civil liability in practice is a messy business, through which courts deliver some compensation, provide some deterrence, dispense some justice, and do some other stuff such as that. If all goes well, they will impose liability, tribunals will impose liability in a manner that contributes to social welfare broadly understood. When courts face difficult cases, they muddle through making what are essentially indeterminate multi-factor policy judgments. It is difficult to identify when we read a judgment a single function, a single policy judgment. Usually they concur together to give the result. However, the growing use of civil liability as an instrument of social engineering should be highlighted. Here in civil law system, I can speak from the Italian perspective, we are witnessing an evolution similar to that of common law system with regard to the role of litigation. Litigation as a way to shape society, not just a way to enforce legal rights, but a way to establish new legal rights. It is set against a backdrop of consolidating this perspective that we can say that the legitimate expression of public values through tort acquires greater importance if we understand the expressive function of tort liability as an opportunity for private individuals to participate actively in constructing collective values, for respecting others in our democratic society, by communicating people's moral intuition about risk, trust, truth. It is, in this sense, a more explicit value-driven discourse about the rationale for non-contractual remedies. This not only fosters democratic deliberation about the nature of our obligations to another, but also as a powerful potential for conveying more nuanced and enriched social messages. It is clear that this perspective is not an isolated trend, but it is part of a framework in which even law is changing its function. Law, I believe, is becoming the last shared morality of a society that is witnessing a fragmentation of values, a fragmentation of principles. It is, or the aspiration is that law becomes the common norm in the absence of common customs. So, in this sense, we are witnessing a fragmentation of society that can no longer recognize themselves in a common discourse, or they can, but only in a very, very general terms. However, it is interesting to observe how often law is not able to unite, but many times accelerate this fragmentation. I believe many times it is a vicious circle. In fact, the absence of a common foundation makes the law weak, but at the same time, law should be able to impose this common foundation. So many times it is very difficult to say how this relationship worked. It was, of course, easier. I am not saying better, but it was, of course, easier when law reflected morality. At this time, these days, this is impossible. It should be noted that, in this sense, a regulatory function of tort law, especially of new phenomena, is indisputable, and it is essential. While, for example, we reflect on artificial intelligence and the problem it causes to our systems, and the possibility of legislating even at European level artificial intelligence, courts are beginning to resolve issues involving it. This determines an evident first regulation of artificial intelligence, and this is often inevitable and probably also correct in cases such as artificial intelligence, where evolution is difficult and very fast, so law can only follow. It is clear, however, that even in such cases, an organic vision would be necessary from which to start, and not simple specific rules. However, it is different when, through civil liability, initiatives are implemented that are in fact very clearly political choices. Here, the issue to me does not seem to be the correctness of the battle or the results that can be shared or not. And at the same time, let's not hide the fact that this is also a problem, because courts answer with a yes or no. They don't know the gradualism that is typical of democratic process. But on the one hand, in my opinion, the real problem is the adequacy of civil liability to carry out these functions in a way that is really the best, or the better. Is it really civil liability the most correct and most efficient tools? And at the same time, we can discuss about the legitimacy of case law, of jurisprudence, in making these choices. The best example, in my opinion, is that of climate change litigation. This judgment, we could say, have a clearly expressive function, because, as it was said, tort has different expressive aims. Tort liability establishes that the defendant wronged the plaintiff, but at the same time, it establishes our values. So, when we say that we care about environment, this litigation establishes, affirms it. And in this sense, they just not express our values. They hierarchize them, because in this case, they balance enterprises, they balance what is the economic initiative with the protection of the environment. It is particularly interesting the Dutch decisions, especially the second one, in which the court used tort law to force a private company to reduce emission in accordance with the targets set in the Paris agreements. Here, I would say there are technical problems and political problems. The first problem, from a technical point of view, is the standing. But since it was dealt brilliantly yesterday by Larissa, I won't enter in this problem, but I believe that in these cases, a generic interest is not enough to justify the standing. Another difficult point is that it is difficult to identify the unlawfulness, given that the company did not violate any legislative parameter. There was no legislative parameter binding the company, and also the causation. It is clear that when we face these cases, we can say that it would be better to expand the traditional categories, but the problem arises of both their reconstruction and, above all, the opportunity to modify the structure of tort liability, with reference to causation, for example. How can we actually determine them according to traditional parameters? And is limiting emission to only one company is really helpful, or are we trying to impose, to send a signal, to send a message for other companies? Also, with respect to damage, to harm, we are expanding it. We are expanding it to the harm to future generation. That might make sense. I don't disagree with it. It might make sense in this situation. But at the same time, we need to reconceptualize the concept of damage, the concept of harm, because we are not talking about harm in a strict sense. The second problem, in my opinion, is a political one. It seems to me a problematic use of civil liability, especially in terms of legitimacy. While not adhering to the view of the judge as the automatic interpreter of the law, because it is clear an old view that really nobody agrees with in practice. In theory, yes. In theory, I know it is a very common view, but in practice, everybody knows that there are always policies, choices, policy selection behind the law. But it is clear that there are limits, especially when these impose general choices on a community. On one end, they could be framed as forms of democratic participation, which through the litigation determine the affirmation of shared values. In this case, the organization that sue the company in order to reduce emission use the litigation as a democratic tool. In reality, it seems to me more complex. Consider that in order to comply with certain parameters, thousands of people are laid off and entire economic areas are weakened. Who makes the choice? Is it up to the judge to decide, and are they able to decide in a way that could balance the different interests in the case? It is clear that this is a question of legitimacy. An American political scientist points out that talking about legitimacy should be avoided because it is a very slippery concept, even while admitting that it is too important. And the problem is that it is difficult to define. The idea of legitimacy originates in the Greece of Plato, Aristotle, Thucydides, and has come to the present day through the various reflections and perspectives of philosophers, sociologists, political scientists, jurists, and psychologists. We can remember so the thesis based on consensus, Rousseau, Parson, Lipset on conflict, Marx, Machiavelli, mixed, Weber, Gramsci, Habermas, normative or descriptive. However, in today's reality, the multiplication of processes of legitimacy, as well as the sources and object of legitimations, complicates the issues. Although, obviously, we can agree with the observation that legitimation is an auxiliary process that determines the stability of any structure or institution, and that forms a connection between what is unacceptable or acceptable and what is already accepted by a group. This determines that the result is respected by those who benefit from it, and especially, and this is most important, by those who are penalized by it. Today the debate over legitimacy is lively in regards with case law, in regards with the role of the courts, and doctrine distinguishes, Fallon, the last book of Fallon distinguishes between legal, social, and moral legitimacy, which often intersect. The judge in this decision is not free to pursue policy goal without considering the test or the precedents. In turn, he must also consider the context, especially since it requires the cooperation of other powers. However, a prevalence of social legitimacy seems to be emerging. Especially in civil law, we are not used to it. And this all poses risk in the long term, at the time when the decision must also respond to social rather than technical consideration. It is difficult to understand why it is the task of the judiciary to make it. The acceptance or different choices could be weakened, but it must be stressed that all profiles must be balanced, because choices that are not aligned with the common sense, are not aligned with the general perception, are perceived as unfair and could still lead to a decline of legitimacy. So it's legitimacy is a tricky thing. In this sense, it is interesting to note that the use by the judiciary in these cases, in the climate change litigation, but in many other sensitive cases, the judiciary uses scientific data and comparative law, albeit to a lesser extent, to establish the impression of the legitimacy of the judiciary and its alleged neutrality. It is clear that the use of science in tort law and in a technological society is clearly fundamental, and it will become increasingly so. Science is not only regulated by law, but often shaped it, as artificial intelligence demonstrates. In civil liability, this is clear in studies of causation, but studies on the brain are also promising important results in quantifying non-economic damages. With reference to science as a source of legitimacy, it is clear that the general idea, or the shared idea, it has that if anything is certain and beyond question for contemporary man is the possibility and the importance of science. Science so is seen as a way to legitimate the use of tort law as an instrument of social engineering in certain cases. Because science is the great power in our age, becoming almost a value in itself. However, its relationship with law is difficult, because while science is a process, law requires definitive answers. So in decision, results are crystallized, but then later these elements can be disproved. In fact, they require elements that are as certain as possible at a given time for a decision. Instead, we should never forget that, as pointed out, the certainty of today may be eliminated by the next generation of experts, and the scientific research will shed light in corners that are currently dark. On the other hand, this is the destiny and the meaning of the work of science, to which it is subjected and exposed in a quite specific way with respect to all the other elements. Every scientific achievement involves new questions and wants to be surpassed, to be overcome, and to grow old. However, this use of science implies, as a source of legitimacy, implies two reflections. The first is the impossibility for politics and then law to abdicate at all its role in relation to science and technology. On the one hand, they are never neutral, but can serve the most diverse purposes. On the other hand, the decision to let science govern, even in this case, when clearly many times the courts say we didn't decide, we didn't decide only based on legal points, we decide because we have scientific certainty. The problem is that the decision to let science govern is a deeply political decision. But above all, in a panorama of frequently conflicting research and studies, A particular orientation is chosen because it seems to respond better to certain objectives. So in reality, we pick our friends in the crowd, as it was said. It emerges how the choice of objectives there is, especially in a certain system, strictly connected to the idea of using science not just to pursue results, but also to help or to improve the function of social assistance or the function of welfare state. The function of social assistance from an individual point of view is always clear in tort law. This function is clear in compensation for damages to health or even moral damage, which are justified by the attempt to help an affected person. We can say that we give them damages to restore his dignity, but at the same time what we are doing is trying to help this person to recover the situation, to live her life with his life with dignity, and to have more opportunities, even in a difficult situation. Often, however, we see decisions that go beyond the individual situation and give rise to real welfare state intervention. This can be justified under the profile of solidarity. In many Italian decisions, we see the use of solidarity in connection with tort law as a way to help or to justify welfare state intervention. Solidarity is the guiding criterion for the judge in the decision in our legal system, not just in tort law, but also in contract law, in many other areas of private law. The main objection to this widespread jurisprudential use of solidarity, however, is encountered in the very nature of the judicial process. I'm not talking about the individual perspective, I am mostly talking about the collective perspective, because we are witnessing this shift. The nature of the judicial process, which directed to decide the specific dispute, should not be a way to solve complex policy problems. Welfare policies must be based on knowledge and information not always available to the judge in the process. Often he does not even have the time or tools to develop them. Above all, they generally involve a trade-off and balance between different demands on the fate of public finances that the decision maker is unable to make. The judgment does not allow for the modulation that is necessary. This is because it does not have the picture of the overall situation and many times lacks the legitimacy to impose certain solution, which could be, the solution could be unpopular, could sacrifice other interests and claims. American justice clearly expressed this complexity, saying that providing relief in such a situation would involve more than applying existing rules of law to new facts. It would require the creation of a new rule in analogy to existing ones. The unwritten law possesses the capacity for growth, and it has often met new demands for justice by invoking analogies or expanding a rule or principles. This process has mostly been applied, it should not be interrupted, where the problem is relatively clear and simple, as it is likely to be when only private interests are involved. But with the increasing complexity of society, the public interest tends to become ubiquitous, and the problems presented by the new demands of justice cease to be simple. Thus, the creation of recognition of a new private right may do serious harm to the public at large, unless the boundaries of the right are definitely established and guarded. So the problem is that a decision that might be correct for the specific case, and we can agree with the decision, might be unfair to the community or unfair to other persons that are in a similar situation. The profile also emerges with respect to the economic sustainability of certain choices, because we should look not just at the individual picture, but also the general one. As it is pointed out, expectation of the welfare state based on personal values, protected in this case by the Italian constitutions, cannot be realistically defined without reference to the concept of economic sustainability. Even when we talk about solidarity, we need to connect the idea with economic sustainability. The consideration of foreseeable practical consequences must in fact be among the criteria used by the judge. It is clear that a very high compensation awarded to a community for a disaster could mean a significant increase in the budget of public entities and the sacrifice of other equally valid claims. The question does not concern the possible validity of redistributive policies, but I would say the identification of the subjects called upon to decide on them and the way in which they must be implemented. Therefore, the reflection of that doctrine that consider compensation and retribution compatible can be shared. We think that it is morally desirable to ensure that people are able to plan and organize their life in a sensible fashion. We must be systematic about both compensation and redistribution. Just as people must be able to count on compensation whenever harmed in certain ways, so too must they be able to count on redistributive policies working in a similarly relentless fashion, no matter whether they are on the giving or the receiving end on those policies. Erratic compensation would be unsatisfactory, and for the same reason we should be unsatisfied with redistribution, erratically taking only from those unlucky enough to suffer harms and rewarding only those lucky enough to benefit from these misfortunes. At the same time, many times we face difficult situations. What if the tortfeasor is really poor and the damaged person is really rich? How can we do social justice in this case? So I believe that the idea of social justice or idea of distribution is many times more complex in reality. So both compensatory and redistributive policy can in this way be seen as a manifestation of broadly the same principles, principles of subjecting the contingency that buffet individual lives to some sort of rational public control. The different functions and objectives pursued by the civil liability leads us to question ourselves on how it should be understood today in a modern sense, and above all in the faces of the crisis of the principle of efficiency. We are witnessing a crisis of economic analysis of law, at least in civil law. That should not be forgotten, but it seems that it is no longer succeeds in explaining fully everything. So more useful, it seems to me, to go back to an analysis of civil liability in a Kantian Aristotelian vision that moves from the idea of the common good, capable of directing politics and law, not so much to the pursuit of an aggregate social welfare, but rather to the promotion of the freedom of the individual in the community. It is a vision that shuns both excessive individualism and collectivism and recalls the vision of social justice elaborated by philosophers or thinkers like Novak that try to connect liberalism and social doctrine. In this sense, social justice is a virtue that empowers individual persons and all peoples to act for themselves, to exercise their inborn and social creativity. This habit of building free association is the first law of democracy, and it is the social habit rooted into individuals and demanded by the new things of our centuries. So it is no wonder that this virtue, the virtue of social, could arise only late in human history, in the age of democracy. Freely formed enterprises, free and independent unions, cooperatives, social initiatives. So the principle of solidarities that should pursue social justice serves to support the individual affected by the detrimental event by helping him to regain or maintain his place in society. In this way, it also functions as a link between individual and collective perspectives. Because it is clear that nowadays we many times use moral damages or non-economic damages as a way to support individuals because communities, because intermediate groups are lacking or are less important than before. It is also inconsistent with the development of that tort has had, which has been, according to few scholars, much more anthropological. It also has been undeniably systemic. As a product of the human mind, tort has expanded in a way similar to the human brain, first dwelling on impulsive behavior, then establishing social solidarity, and finally generating the capacity to make rational decisions. Tort passes through the selfish, the social, and the rational stages of life, adding every time new coping mechanisms as they fumble toward adulthood. It should be noted that this perhaps determines the need for a minimalist view of civil liability. After a year of expanding tort law, of expanding civil responsibility, we should recognize, in my opinion, the insufficiency of law and the impossibility of making everything juridical. A society that has only the juridical balance as its disposal can truly be said to be worthy of man. We should recognize its role, we should recognize that tort law has important objectives, but at the same time, tort law can't do everything, or can't do everything in a way that is good. It can, maybe in the long run, but not always in the way we need it. On the other hand, I believe that civil responsibility must focus, should focus even more now than ever on the person and place the person and the protection of the person at its center. Thank you very much.